This is the One World Trade Center building, colloquially known as the Freedom Tower. It's the main tower of the now reconstructed World Trade Center site in New York City. Of course, it's most famous for being a part of a complex memorializing the victims of the 9/11 terror attacks. However, did you know the designers and developers of this building have been sued twice for copyright infringement? Once in 2004 and again in 2017 for allegedly copying the designs originally developed by other architects years ago. The architecture firm responsible for the design, Skidmore, Owings, and Merrill, denied these allegations and claimed any similarities in design are basically simple geometry that are industry standards and by no means unique. So is there a threshold of originality for a building to be copyrightable? Can you even copyright a building? And if so, how does it actually work? Before I go any further, I should say I am not a lawyer, and this video is definitely not legal advice. This is not just a disclaimer to cover myself. Through researching this video, I've discovered that copyright law is really complicated, and of course it differs depending on where you are. So you should obviously consult an actual lawyer if this is something you're concerned about. But if you're just curious about how copyright works in architecture on a basic level, here's a very general and broad overview. Can you copyright a building? The short answer is yes. Architecture is generally considered an art, similar to painting, drawing, and sculpting. And similar to other works of art, someone who creates an architectural work is entitled exclusive rights to use the work for a limited period of time. The terms of copyright and how long that limited period is depends on where the copyright holder is located. However, the vast majority of the world implements a version of the Berne Convention for the protection of literary and artistic works, an international copyright agreement that, as of April 2022, has been adopted by 181 nation states. The United States, for instance, joined the Berne Convention in 1989. Prior to that, architectural works did have partial protection under previously passed copyright protection laws, such as the Copyright Act of 1909, which included protection of drawings or plastic works of a scientific or technical nature. This was clarified by Congress in 1976 to include an architect's plans and drawings. In 1999, Congress passed the Architectural Works Copyright Protection Act, which provided protection for the design of a building in virtually any form. An architectural designer could seek protection in two ways: registering the creative work as pictorial, graphic, and sculpture works, or through registration of the building designs, including but not limited to architectural plans, technical drawings, other construction documents, sketches, models, illustrations, and digital renderings. The Act also covers the overall forms, arrangements, and compositions of spaces. This protection, however, does not extend to common architectural features like windows, doors, and other staple building components. Certain standard and long-established architectural features like classical orders and other recognizable historic styles are also not protected. The protection also doesn't include design elements attributable to building codes, topography, engineering necessities, and other general functional elements. Another important distinction is that since copyright protects creative works, it does not apply to newly developed technology or improvements on products and processes. These fall into the realm of patents, which is a discussion for another time. Copyright is also different from a trademark, which is the composition of letters, words, sounds, or designs meant to distinguish one company's goods or services from another. Historically, trademarks are applied to 2D designs like logos and packaging. However, in 2013, Apple managed to register the design of the Apple Store as a trademark, which kind of complicates this distinction, but again, story for another time. Back to copyright. In order to prove copyright infringement, you must not only demonstrate that someone has indeed copied and reproduced protected elements from a work you owned the copyright to without your permission, but also that they had access to your work, and the two works are substantially similar. This means that making minor changes to someone else's design can't get you out of being accused of copyright infringement. A work also doesn't require the copyright symbol or copyright notice written on it in order to receive copyright protection. Additionally, just because someone paid for an architectural plan or a construction document, the copyright doesn't usually get transferred to the owner or constructor. Usually, the original architect architect still retains the copyright and are granting a non-exclusive license to the owner or contractor to use their material for a particular construction project. Having said all that though, how architectural copyright infringement claims unfold in reality is quite complicated, inconsistent, and murky. According to the American Institute of Architects, many architectural copyright infringement cases have actually demonstrated how thin the level of copyright protection for a functional building is. Because some architectural designs, such as the design of the vast majority of single-family homes, mostly consist of standard features arranged in standard ways. This often makes architectural works the least protected art form because basically anything with an intrinsic utilitarian function is likely not protectable. The two cases of copyright infringement claims for the Freedom Tower I mentioned earlier were both withdrawn by the plaintiffs after settlement agreements with the defendants before the cases ever made it to court. Another high-profile example is the 2008 Oravec versus Sunny Isles Luxury Ventures case involving a 43-story high-rise condominium project. In 1995 to 96, designer Paul Oravec developed a design for a high-rise building that featured alternating concave and convex segments and elevator cores protruding through the building's roofline. In 2008, Oravec filed an action under the Copyright Act against parties associated with two condominiums collectively known as the Trump Buildings in Sunny Isles Beach, Florida, for allegedly being derivative of his designs and thus in violation of those copyrights. The 11th Circuit Court disagreed with his assertions since copyright protection does not extend to ideas, but only to particular expressions of ideas. The similarities between the Trump Buildings and his designs were nothing more than at the conceptual level. Thus, they concluded that copyright will not protect the mere idea of a convex/concave building any more than it would protect the idea of an arch or dome or tower. However, this doesn't mean that the particularized expression of these ideas cannot be protected within the context of a particular design. The court stated that while it is true that Oravec's designs and the Trump Buildings have a number of features in common, these elements are similar only at the broadest level of generality. To protect this level of generality would lead to a diminished store of ideas available for future works. In Canada, architectural works are also protected by its own Copyright Act of 1988. Prior to 1988, Copyright Act required architectural works to possess an identifiable artistic quality or character. Since 1988, the artistic requirement was removed. Architectural works are required to demonstrate originality. However, what is considered a threshold for originality was not defined and thus left to the discretion of the court. In the 2017 case Lainco Inc. versus Commission Scolaire de Bois-Franc, the Canadian Federal Court confirmed the plaintiff's claim to copyright protection of their steel structure design for an indoor soccer complex. It was the first time in 50 years a building structure has been granted copyright protection in Canadian courts. The defendants, which were a school board, their architectural firm, and the general contractor, had to pay nearly $750,000 in damages to the plaintiff for infringing on the copyright of their work by building a nearly identical soccer stadium. The defendants admitted to photographing the original complex's steel structure while it was being constructed, proving that they had access to the design. However, the defendants claimed that the steel structure performed a utilitarian function and was therefore not copyrightable. In the decision, Justice René LeBlanc indicated that copyright needs to strike a balance between the protection of the work while allowing for the free flow of ideas in the public domain. Even though the structural design of this building was composed of simple industry standard structural elements, the arrangement of these elements to form a whole had a level of complexity and originality that met the court's opinion in regarding it as not a purely mechanical product, but a aesthetically pleasing and cost-efficient design assembly that required skilled discretion and judgment to develop. This case demonstrated that even though the lower burden of what qualifies as a copyrightable architectural work was established in 1988, it took nearly 30 years for courts to eventually recognize and enforce this greater protection. Even though there have been a handful of successful architectural copyright cases, very few cases still ever make it to court, and even in successful ones, the damages awarded are often significantly lower than what was claimed. In some countries, such as China, copyright protection is even thinner. There are many replicas of famous buildings and even entire copies of villages in China. However, in 2013, someone actually actually tried to build a copycat design before the original building was even done construction. The late architect Zaha Hadid's design of a retail complex in Beijing was in a race to complete construction, while a near exact replica of the design was being constructed at the same time in Chongqing. In 2020, the Chinese government decided to clamp down on this type of behavior by passing new laws that prohibited the plagiarizing, imitating, and copycatting of designs in new public facilities. I haven't come across anything that indicates whether these laws are actually being enforced, but it's probably too early to tell. On a somewhat side note, many of you may be wondering if photographing a building could result in a violation of copyright. In most cases, no. When a building is ordinarily visible from a public place, the copyright owner cannot prevent the making, distributing, or public display of pictures, photographs, or other pictorial representations. You may have heard about how it's illegal to take pictures of the Eiffel Tower at night. Technically you can, but the picture has to be for personal use. The prohibition is that it cannot be used for commercial benefit. So if you're a photographer who wants to sell nighttime photos of the Eiffel Tower, technically you can't do it without the permission of the copyright holder, Pierre Bidot, who was responsible for the light installation of the Eiffel Tower in 1985. This is because French law does not have the same copyright exception for buildings visible from a public place, so the copyright holder retains exclusive rights of its distribution, including photographs, for the lifetime of the creator plus 70 years. You can distribute pictures of the Eiffel Tower taken during the day, though, when there are no lights, because Gustave Eiffel died in 1923. This is also why people have been free to create exact replicas of the Eiffel Tower, as long as they don't replicate the exterior lighting design, since 1993. So that's architectural copyright. It's confusing, difficult to enforce, but also necessary to help protect works created by architectural professionals so we can make a living, but also to maintain the free flow of ideas so we can continue to create and innovate. If you're interested in learning more about copyright, I made a video about the Creative Commons a few years ago. The link is in the card and description below. Thanks for watching. This video involved a lot of research and reading through long, boring legal documents. If you enjoyed it and would like to support the channel, feel free to drop a tip in my coffee jar. See you next time. Bye.